Talk about this other important story this morning, and that's Facebook being fined. The Federal Trade Commission set to slap a massive penalty on Facebook over privacy issues as well as sharing data. Jackie DeAngelis is covering that story. Jackie.
Good morning to you, Maria. That's right. It's a $5 billion settlement with the FTC and Facebook, and it's actually the largest civil penalty ever paid to the FTC. What the FTC is saying here is that Facebook violated a prior order from 2012 concerning privacy issues, and that's what this fine relates back to. What's really interesting here, a privacy committee has to be set up. That committee has to be independent. CEO Mark Zuckerberg, he's got to certify that the company is complying with the rules. That's on a quarterly and annual basis. If he makes false statements, he would be subject to criminal and civil penalty himself. So Zuckerberg taking on a lot of responsibility here. And it doesn't just deal with Facebook, but it also deals with WhatsApp and also Instagram and any new products that Facebook may offer in the future. A couple of other privacy restrictions included in this. Facebook is banned from using phone numbers to enable security features. Facebook must exercise greater oversight on the third-party apps that it works with. It must provide clear and conspicuous notice of facial recognition if it's going to use it. And it's prohibited from asking for email passwords for other services that it's connected to. In an interview with Fox Business, the FTC Commissioner Christine Wilson said the order creates a robust system of checks and balances that spreads responsibility and accountability for consumer privacy. But Maria, largest civil penalty ever paid to the FTC, $5 billion. This is a huge amount of money we're talking about, and huge in terms of setting the stage and the scope of what's to come in terms of social media companies and privacy issues.
All right, thank you, Jackie. Huge fine that Facebook is facing, Judge. And it's also part of this other bigger story where the Attorney General has started a new antitrust inquiry into big tech.
All right, so this is an inquiry by an administrative agency. Even though it's an administrative agency, it's still the federal government. It's hard for me to take seriously the federal government fining some entity for violating privacy when the federal government itself is the biggest violator of privacy on the planet. Nevertheless, this is what they do. $5 billion is a lot of money, but it's a drop in the bucket for Facebook. The reason it is so high is this is an express violation of an agreement previously entered into. You can get away with one of these, but you violate an agreement that already restrains you, that's already in place, they're going to come down on you very hard. As for the Attorney General's investigation announced yesterday, this is some sort of anti-competitive investigation. I don't know how he's going to show harm to consumers. Facebook is free. Google is free. There's no amount of harm to the consumer.
Conservative conversation, Judge. I mean, like
they can do that. They're not the government. So they can censor anybody they want. I know it's harmful and hateful, but they can do it.
Google has 90% market share. So if Google has 90% market share in search, they are the big kahuna on search. And if they are putting certain headlines in a search, if I search Donald Trump and I'm getting all these ugly headlines, and then I search Hillary Clinton and I'm getting Hillary Clinton is a superstar, she's the best thing since sliced bread. Is that censoring information?
It is.
And using their 90% market share?
It is, and it's lawful. And if you don't like that search engine, use another one. The First Amendment doesn't restrain them.
But they've got 90%.
Well, that's because they're so successful.
I have a question, but not an answer about, slanderous material. If somebody gets on one of these platforms and commits slander per se, and I complain against you, and you complain about it, and they don't take it down, what's their liability?
That's a very good question, and I'll tell you where.
That's why Devin Nunes is suing Twitter.
I'll tell you where that door has been opened. So if Amazon sells a product from a third-party vendor, and the product harms somebody, and the third-party vendor doesn't have insurance or goes out of business, Amazon can now be sued for the first time. Supreme Court ruled on that just about a month or so ago. That is opening the door to litigation over this. But doing something to Google because you don't like their politics, the answer is find somebody else and compete.
Well, I think
that doesn't fly if they're a media company.
Why?
Because
media companies protected by the First Amendment.
But they're saying
they're going to come after Fox because we dominate a certain
they're
viewpoint?
saying we're not content creators. We're just the platform. In fact, they are creating content. That's what Devin Nunes is suing Twitter about, that they create content. They cannot call themselves a tech platform.
They're not under the law. They're under the law. These companies are not considered media companies, and they cannot be sued for defamation. That was a law that was passed in the mid-'90s, really at the very beginning of the growth in the internet.
That is going to be for reasons just articulated, re-examined, because this is really the Wild West of whether or not you can publish something that you know is false. It's one thing for them to say, Judge Napolitano doesn't know what he's talking about. Yeah. But if they publish something they know is false, that's a very serious issue.
I think to Maria's point,
which is what Twitter did.
Because I want to add one thing to what the judge was talking about, and these are two separate stories in the Wall Street Journal. The Justice Department, the broad review of the big tech companies for antitrust issues. And another story in the Wall Street Journal mentioned earlier on the show, Apple dominates the App Store search results, thwarting competitors. That's the gist of it. Search for music, audiobook, other categories rank company apps first. Developers find this unfair. Apple says, oh, well, our algorithm doesn't do the algorithm's not written that way. Well, but again, blame the algorithm. How many times have we heard that?
Somebody programs the algorithm.
Somebody does, but when Apple put up an Apple Store, they invested a lot of time and money into the Apple Store. So I think the argument can be made that they can promote their product. And as the judge was saying, if you don't like it, you as a developer, you can choose to only put your product on Android or on Google's platform. So I think the ultimate thing here will be for the big tech companies. Like if you're aware, you the public know, you go on Google and you search for something, you're going to get a anti-conservative bias or a very left-wing type bias, then you may choose to go to a different search engine. So I think the ultimate thing here will be them policing themselves. And if Apple is going to promote their products above someone else's, now you know about it, so you can choose to deal with it or go elsewhere.
But the linchpin of all criminal antitrust prosecution was the consumer harmed? And if the government can't show harm to the consumer, it doesn't matter that Apple favors its own products.
Well, Devin Nunes was harmed.
Well, that's not criminal now.
But he was harmed.
These are apples and oranges. Whether Devin Nunes was harmed is irrelevant to whether or not the DOJ is going to have a successful criminal prosecution of the four big tech ones.
All right.